Hello, everyone. I'm Jay Lyman. I'm a librarian with the Seattle Public Library, and I want to welcome you here to this event on commercial leases. I'm super excited that we have Michael Jonas with Narwhal here who's going to present, and I'm going to just turn time over to you, Michael. Thank you for being here.
Yeah, absolutely. Thank you for having me, and nice to meet the people on the call, and nice to meet the people who are listening from home after this is recorded. So today we're going to talk about commercial leases. Um, Before your eyes glaze over, know that I'm a pretty casual attorney, and a lot of what I do is about law, but also about strategizing and building communities. So hopefully it won't be too lawyerly. So with commercial leases, we have high stakes, we have hidden terms, we have hard lessons. A little bit about our firm before we get started. Narwhal Law and Business Strategy is a certified benefit company, meaning we care about not just profit, but planet and people. We offer a variety of business law and business strategy services throughout Oregon and Washington. And basically, it's a law plus. So, especially with something like commercial leasing, there's a lot of strategizing, negotiating, picking your battles. So, we're here for you in that process. So the first thing I want to talk about is commercial leases are a Wild West show. And what do I mean by that? First of all, they could be 65 pages. They could be partly from 2011, partly from 2020, partly from a week ago. They could be part of multiple tenants' leases cobbled together. So they're sloppy, and what makes that difficult is they're standard boilerplate agreements that are often not specific to begin with. And then we add in random clauses and random specifics about companies that are not ours. And then we sort of get that hodgepodge document. The other reason why they're a Wild West show is they don't have the same protections as residential leases. As you know, in Washington, both Washington and Oregon are very focused on landlord and tenant laws relating to residential properties. In the commercial lease space, they don't have to worry about habitability. We're not talking about making sure that someone can live there, and there's more focus on profit and business growth and development and getting taxes from businesses. Whereas with residential, we're more focused on are we following housing laws, civil rights laws, is the place heated sort of thing. So that's another reason why. Another reason why that they're potentially more complex is that we have all kinds of commercial leasing sort of motivations. We have commercial leasing motivations of lease it to anybody and make the money. We have, uh, you know, let's rejuvenate this area, whether or not that's actually performative or legit. There's a component of that. There's also a component of do they care about my business or do they just want my money for the lease? So there's a lot of questions we have to ask about motivation. We also have to challenge this sort of patriarchy, hierarchy of, you know, this is what you have to agree to be here. And if you don't, then you can't be here. What I'll tell you is a lot of clients immediately think that they don't have the ability to negotiate, and that's actually not true. One of the beauties of commercial leases, despite being a Wild West show, is there's actually a little bit more room for tenants to negotiate. And I often tell my tenants that the landlord needs you just like you need them, because the assumption or based on past trauma is that that's not the case. It's I have to do everything that they want me to do, and they're not going to take the suggested edits. And the reality is that's not true. They need your money, and they should be listening to you on what suggestions you have. So these are some key goals that we're going to talk about today. We're going to talk about some of the hidden risks, understanding some of the major lease clauses, how to negotiate more effectively, and then avoiding expense surprises. So these are just a few reasons why commercial leases go wrong. So one of the mistakes is only focusing on rent. I am going to pay this much money for this much time or this much money for the year. And so when I say focusing on only rent, that could be that you're not thinking about all the other charges that you may have or all the other liabilities that you may have. Um, you also maybe aren't thinking about editing the permitted use or editing or negotiating other things. So in in sort of retrospect of like you're gonna be at this place doing your business for this amount of money per month, we have all these other things in commercial leases. We have tenant improvements, we have permitting, we have zoning, we have what the neighborhood association wants. We have, do you have liability to fix the HVAC system? Who has that liability? What happens if the roof goes bad? So there's this massive scene of all kinds of other things that a lot of times both parties can only focus on the rent, and sometimes they sell it that way. This is your charge, I'm giving you a discount for the rent. Well, that's great, but if you factor in all of these other things, you potentially have more charges and more liabilities. So that's one of the biggest mistakes is you get excited about the space, you find out it's affordable for your business plan, you move forward, but you don't look at all the other things. Another one is ignoring CAM charges. I'll talk about CAM charges later in more detail. CAM charges are common area maintenance. Common area maintenance is CAM charges. So a lot of landlords throw a variety of things into this, but it could be there's a lobby. It could be that there's a cleaning company. It could be that there's landscaping. There's a long list of potential common area maintenance. And the question is, do I really want to be paying for that and what percentage? And if I get into the situation and I don't really have an idea of what those additional fees are, then we have a problem. It kind of makes me think of HOAs for residential property. We want to know, like with an HOA, is there a pool? Are they doing landscaping? Am I doing landscaping? Or are they just going to decide like these are the things we do or don't do? And so a lot of times it's good to know not only what the common area maintenance things are and what they're going to cost, but actually, do you support those? Do you want them to spend this percentage of your money doing that thing, like cleaning up the parking lot? Or it's some of them, yes, that's great, and you should. And some of the buildings you might be thinking like, this is outrageous. I don't think that they need to be spending this much money on common area maintenance. And then as a result, I shouldn't move forward with this building because I have my regular base rent plus tons of fees that go out to a variety of third parties, right? Um, some commercial leases, another one is skipping zoning review. So um, you may know that buildings are zoned based on occupancy or based on all kinds of things. Liquor licenses, can you open another spot with a liquor license or not a liquor license? Can you have food? And there's fine nuances. So some spaces are you can sell food, but you can't sell food on the street. You can sell food, but not to go. You can sell beer that is in a can, but you can't sell beer on tap. So a lot of businesses, unfortunately, they don't dig deep into figuring out what the zoning requirements are. And also, this works not just for beer. I was talking to Jay about how some of the folks were daycare providers, and same thing for that. You have a daycare in a residential area. Does the zoning allow for a daycare to be there? And the answer might be no, or the answer might be in order for that to happen, you have to apply for either a permit or a variance. A variance is asking for a zoning exception. So basically saying to the city, I know that this is zoned this way for our particular business because this is needed. Will you approve a variance to allow me to basically violate the zoning, but you've given me permission to do that because we need this sort of thing in our neighborhood. So that's a big mistake is skipping zoning review or not focusing on permitting, zoning, that sort of thing. Another one is signing personal guarantees blindly. I think there's another slide further down on personal guarantees. A personal guarantee, if you don't know, is you are agreeing to if your business closes or your business can't pay or your business goes bankrupt, that you personally will be responsible for the remainder of the lease that's owed. The problem with this is a lot of commercial leases, or almost all of them now have this, but there's a thought that if I go bankrupt and my business closes, oh, I must not be liable for the lease. And the answer is that's not true. If you signed a personal guarantee, what you're doing is you're preemptively giving them permission to what's called piercing the corporate veil. You're giving them permission to go through your corporate liability or your corporate shield into your own personal liability. And so the sad thing is that if you don't understand that correctly, or you don't have a personal guarantee that either drops after a couple years or has some sort of warning, they can go after you personally. And so you not only lost your business and can't pay from a business perspective, you've preemptively given them permission to go after your individual assets. So there's that. And then another one is failing to plan for growth or exit. So I always like to think of, both for me and for my clients, if things went really well, could I get out of this? Could I find another tenant here? Could I, um, whatever it may be? If things go really crappy, could I leave? How could I grow? How could I exit? Could I have other people here using the space? And we'll go into some more specifics about that. So these are kind of the why commercial leases go wrong. Another one that I didn't add to here is not understanding what a fixture is. A fixture is something that stays with the property. And so, for example, sometimes landlords and tenants argue about it either in the beginning or in the end. So, for example, you spend $10,000 on a walk-in, and there is this question of, after I move, does the landlord believe that they own that walk-in fridge, or they own that pizza oven, or do they have to pay me for that because I own it and I've decided to leave it there? So there's a lot of questions of what's deemed to be a fixture that becomes property of the landlord or owner, and what is deemed to be something I can either take away or ask the landlord to pay me for as I'm leaving because I've increased the value of their property. So that's another big commercial lease issue that we see a lot. Okay, so in order to understand leases, we have to also understand the lease structures. What's difficult in understanding these is they're not always perfect categories. So there are things that kind of look like this, but are kind of that. So we have, for a gross lease, that the landlord pays most building expenses. We have a modified gross, the costs are shared, every lease is different. We have a triple net, which is probably, I'd say, the most popular now, is that the tenant pays the rent, the taxes, part of the taxes, part of the insurance, and part of the maintenance. So that's often something we see. Um, the focus is on total occupancy costs, not advertised rent. So what I want you to understand about this is that this is basically what I said about you may think the lease is this amount per month, but if you don't have a good idea of what you're paying for taxes or insurance or common area maintenance, if you have a triple net, or what you're paying for the other costs, some gross leases actually fluctuate the percentage of the lease based on sales. So they'll say, this is how much you owe as a base. If you do really well, you pay a higher percentage of rent. I absolutely hate those leases. I tell clients never to get in them, but a lot of those still exist where the landlord says, you do really well, you pay me more. I'm not a fan of that. So yeah, this is kind of like, yeah, and you don't have to know all the specifics of these. Just know that if you don't understand the other costs besides your rent, we have an issue. And if the landlord isn't open enough to give you a history or an accounting of what the averages for these things are, then we have another issue because we agree to it. And someone might say, oh, it's kind of a range, or it's kind of this or kind of that. Like I don't want that. I want to know exactly how much I'm going to owe for these other things on top of my lease. So total occupancy costs. Um, so this is kind of the same thing is we're not often asking ourselves, what do we owe besides the base rent? Common area maintenance, I talked about that, like lobbies, cleaning, helping parking, security, all kinds of things, power washing, whatever. That all gets thrown into common area maintenance. You might be paying towards taxes, insurance, utilities, repairs, maintenance that's not common area maintenance, like maintenance on your own unit. And you might be paying for parking. Sometimes there's parking enforcement. I've also seen, which I forgot to add on here, is I've been seeing some owners charge a fee or a percentage for them to pay a property manager. So you, out of your lease, are paying part of the property manager's fees. So you get the point. The point is, what am I actually paying each month? One person, you could be like, okay, $5,000, that's all inclusive. Someone else is $5,000. It actually ends up being $8,000 when you add in all these other costs. So um, we have to figure out like what those costs will be. And again, if the landlord can't tell you or the owner can't tell you, or they can't provide you any information, because they could if they tried, then immediately that's a red flag for me and for my clients, which is like if they're not going to show you what you're going to be paying, then I have a problem with you getting into this contract. So this is the leasing timeline, and of course, this can vary a little bit and slightly. So we're going to want to select sites, see sites. Some clients find a site right away. Sometimes it takes longer than that. Sometimes you have two sites you're interested in. So site selection is important. And when I say selection, I don't mean that you yet have to lease. I mean, you have these sort of must-haves, right? Like I needs to be in Capitol Hill and, you know, upstairs office, downstairs retail, or whatever it may be. And you have, okay, perfect. I like that. I'm going to go forward with that. This sometimes happens is an LOI. I've heard it called letter of intent or letter of interest, whatever you prefer. And what that can do is can let the commercial lease landlord or owner or property management company, whoever's showing the property, broker, know that you're interested in this property. And one really helpful thing with the LOI is before we get into the back and forth negotiating of a 60-page lease, we can sort of narrow down to see whether this is a go or not. So for example, in the LOI, we can say, I want to be sure that there is ample parking. I want to be sure, like I can list a bunch of things and then based on what I had back, I could find out like absolutely not, or no, I can't move forward, or yeah, I can move forward. It sounds like they're gonna, and an LOI typically by default, just like an MOU, it's not by default legally binding. It is meant to be a letter of interest or intent to tell them what your goals are and what you're looking for, maybe a little bit about yourself as well and the business that you're trying to have. Do all my clients have that? Do they go with an LOI first? Some do, some don't. Some go directly into the lease and review the lease. Um, Sometimes that's fine. It works out. The lease ends up working. They end up moving there. Sometimes, had we had done the LOI process, we would have prevented going through the lease review and negotiating and not getting to a point of agreement because had the parties right off the bat figured out what were deal breakers or what were must haves, we would have not pushed forward. So the LOI I highly suggest if you're able to do that. Uh, and I would also suggest if you are going to do an LOI, make it more specific than just a fun excitement. Like don't just say I'm kind of interested because they're not going to take that seriously. So it's got to be, I want to move forward and here's the terms. Can these terms work for you? Okay, and then we have in the leasing timeline, we have a lease draft. So sometimes a landlord will have a lease ready and they're like, okay, here you go, we're ready. Or sometimes they're going to prepare a draft for you and they're like, I need a week or I need 2 weeks to get you a lease draft. And then, we review it or you review it. We talk about uh, what you want to do, like what kind of battles, maybe you send it to me and I immediately go, these are the red flags I have. Uh, I have, when I work with a client on commercial leases, I have different levels of involvement. Sometimes I'm the one who is communicating with the other parties directly. Sometimes it's my client is, and I'm behind the scenes strategizing with them. And then sometimes it's kind of an in between where they communicate with them, but they put me on the email and they say, I just spoke with my attorney. Here's what we're thinking. And my attorney's on the email if you have questions. So, depending on how the client wants me to get involved or who the parties are, how they feel comfortable, I can be as part of the negotiation as desired. And then we have a due diligence kind of component of, um, finances or what do we need to do to get you in the space? That could be tenant build out. That could be, um, you're going to need a sink. Well, we have to make sure that the city is okay with permitting a sink here because if they're not, then we can't move forward. So there may be some third party questions to deal with and some information to exchange. Some clients have financing contingencies. So in order to lease this space, I have to get a business loan or I have to make sure that I have the money coming in to get this space. That could also be for the tenant improvements because I love the space, but in order to do the tenant improvements to make this warehouse into a bar or a restaurant, I'm going to have to make sure that I can get the financing for that. And then, of course, we have the build out and then we have the occupancy. And a lot of folks don't know that a lot of times you can negotiate with landlords and ask them to not charge you for the lease or charge you a lower rate until you've actually gotten your business up and running. So sometimes they abate the rent for a month or 2 months or until certain parts of the build out are done, meaning you're not yet done, you're not yet ready to open, you're still building out. You shouldn't be paying the lease in full. If that is required and if that's what you're okay with, then sure. But if you're not able to pay that or you don't believe you should, that's something negotiate that is worth negotiating. Is you're giving me 1 free month. I actually need 2 free months because I have to do X, Y, and Z. So that's a negotiation term of not paying the full rent until those 2 months are up. Everything is negotiable. So some of the things that are on here are rent. So for example, the total of the rent is negotiable. I sometimes encourage my clients to do market research and see what other properties in that area are renting for. Sometimes that's misleading because, like I said, if rent is advertised lower, but there are a variety of costs above that, it could be that you see another place that seems like it's lower, but the reason why it's lower is because of the base rent being lower, but all the other parts added up end up being more. But it's still good to do research to see what that looks like. You can also negotiate rental increases. So you can say, well, you can increase by this percentage, but not that percentage. So it's like increases for market adjustments are allowed, but only up to 4% a year or something of that nature. So you can sort of add rental increase contingencies that you get the landlord to sign so that if the rent does increase, it only increases for a short amount or based on some other factors. CAM caps, so we talked about common area maintenance. We can say that this is the monthly cap. So, if the landlord decided to be extravagant or upgrade services for one of the people who is, they decide to, let's say, it's springtime and they decide to put out all kinds of spraying pots and that's great and it's beautiful, but suddenly that month your common area maintenance costs are doubled, and so if you had a cap they wouldn't be able to contractually charge you that increase for that month or those months. So that's a possibility. Another one is TI allowances. So TI is tenant improvement. So a landlord might say, if you rent this space, I'm going to give you, $10,000, $20,000, whatever it is, to build some walls right here, or I'm going to give you this amount of money to fix these windows, or whatever it may be. So some TI gets paid for, entirely by the landlord. Some TI gets paid for entirely by the tenant. Some is shared. So I've seen with clients half of the tenant improvement expenses get paid by the landlord and half of them get paid by the tenant. So that is negotiable. And if you think about it, the question is, well, why would a landlord pay um, for tenant improvements? Now, if they have sort of a box of a warehouse or a bunch of boxy commercial spaces, you actually increase their property value by adding restaurants and things like that. Um, or it makes it more rentable because after you leave or when you leave, they'd be able to have quicker turnover and not have to do that tenant build out again. Um, the other thing is that it may make all their other properties around that property more valuable. So if they give you the money to do a restaurant, and then because there's a restaurant there, all the other commercial spaces get taken up. So there's a desire to help you with fulfilling those tenant improvement dollars so that you make the whole property more valuable or more attractable by renters. Another one is guarantees. So I talked about uh, there often or almost always being a personal guarantee where you are saying that if you can't pay the rent from a commercial space or a commercial perspective, your business can't pay, your business is bankrupt. We can sign a personal guarantee, but we can say to the landlord, is it possible to only do this for a year or 2 years? Or if I gross this amount, we won't guarantee that. Or if the business goes bankrupt and you will require a personal guarantee, can we do it so that you don't poke the corporate veil and get to my individual assets until you've done X, Y, and Z, or you've waited this amount of time? So we're sort of adding information or negotiating components into the personal guarantee so that it actually works for us. Okay, and then parking. So parking's a big one, especially in uh, Portland and Seattle and any sort of urban area, right? Like maybe it's that there is first come, first serve parking in a parking lot, but maybe you need a space to load either for you or someone delivering things. So could I say to you, I'm going to rent the spot, but you have to make one designated spot for us, for our company, for loading. And I've seen that successfully negotiated by landlords. Signage. So, where can I put signs? Can I, there's a lot of, some people spend a fortune on signs. Uh, can we make it so that the sign that I get is this large or this small, or, um, you know, maybe you only say one sign, but I really want to have those A-frame signs all around the building so that when people are walking, they know where to go and they see us or they know we have specials. So if you're not going to allow me to do X, Y, and Z, will you allow me to have five of those A-frame signs that are all around the neighborhood and not have a problem with it? Renewal rights. So maybe you don't want to renew, but maybe it would be good to have the right of first refusal to renewal so that if you do want to continue business there, the landlord, after your lease is up, doesn't immediately want to rent to someone who's paying more. So you have the right to say yes or no to renewing. And then repair obligations. So that could be anything. That could be, we have the right to repair this. You have the right to repair this. We'll split the cost of this thing. So I'm not 100% um, liable as a tenant. So you can negotiate who repairs what in a very nuanced way so that neither party is focusing on paying, repairing for everything. The due diligence and zoning and contingencies. So kind of talked a little bit about this. We want to investigate zoning and permits and utilities and parking and codes, and then consider contingencies for financing. So if you're someone who's getting a loan in order to actually move forward with this lease, because we don't want you to sign it and then owe that money if the loan doesn't arise, we want to add contingencies. So, for example, another one would be I'm going to open a bar or restaurant, and in order to do that, I have to get an alcohol permit. If I don't end up getting the permit, the landlord's still going to say that I'm legally responsible to fulfill that lease. So what we're doing is we're adding a variety of contingencies so that if those things happen or don't happen, I mean, we would be able to get out of the lease and not be required to pay them or not be in breach of the contract. So, um, a landlord might not like that because if they're doing tenant improvements and you build out a bar or restaurant, but at the end of the day, they're going to have a bar or restaurant that's ready for someone else to rent. You shouldn't still be responsible for that contractually if your loan for either the business or the tenant improvements didn't come through. So consider adding contingencies that make it so that the lease is null and void or doesn't, should these things not happen, the lease will, you know, it won't be upheld. It'll be deemed null and void if those things don't happen. Okay. So the fine print in leases have teeth. And what this means is that a lot of people are always focused on the rent and the security deposit and all of that, but you really need to look at some of these things closer. So one of them is default clauses, like what is considered you being in breach of this lease. It could be that it's vague and we want them to be more definitive, and so we ask them to clarify. It could be that something you do is not a default, or you should know if there's a grace period. If I don't pay my rent with this amount of time, I have 6 days to pay my rent. And then if I don't pay my rent after 6 days, then I'm in default. So a lot of people don't look closely at the default clauses to see specifically what happens if there is a default. And then the other one is rent escalation. So I kind of discussed this a little bit. Um, it could be that it says that the landlord has the sole discretion to raise the rent. And so if we have rent escalations, if we're okay with that, that's fine. But we want to make sure that those are capped and that we know what they are and that we're prepared for them. And then notice requirements. This could be your landlord visiting and saying, you need to do this. This could be them doing work on the property, which is disruptive. So instead of saying the landlord can enter, whenever they want or within 24 hours, it's got to be very clear of like, you can enter, but you can't disrupt my business. Or for this thing, you have to give 72 hours. For this other thing, 24 hours is fine. So notice requirements are really important because, for example, the landlord decides that they're going to do power washing on a certain day, and you're deciding you're doing a pop-up market that day, or they're going to be repaving the parking lot, and it's going to be a couple weeks of a project, and they don't actually tell you. So being nuanced with what kind of notice, which could say you have to give me as not 24 hours, but you have to give me as much notice that's reasonably possible so that, hey, you knew that this parking lot was going to be repaved a couple weeks ago, but you told me 24 hours ago. So that's important as the notice requirements. As is clauses. So, um, you know, I actually am dealing with a client who has an issue. They're able to get out of their lease, which is good, but they sign an as-is clause, and they're improving the building and getting ready to open. And then, we found out that a bunch of the work that was already there from like 30, 40 years was unpermitted, and there were earthquake issues or potential earthquake issues if an earthquake happened. There was like faulty wiring. So the landlord wants to then turn back on you and say, well, this is as is. You took the property and you knew that you'd have to do improvements. And they were trying to lump in tenant improvements with fixing it to be compliant, which I was upset about because that, to me, a tenant improvement shouldn't be making something actually safe or making something what you presented it as. So there was like a misrepresentation question of, yes, it's as is, but you presented it as this type of occupancy or that these things actually worked. So be very careful with as is clauses and what they mean and what's considered as is, and ask all the tough questions. Okay, you've told me that this is broken. How broken? You've told me that this might be unpermitted. Okay, when's the record that when was this built? And can we actually get conclusions on whether it's permitted or not? Like any sort of speculative things that are considered as is are always good to ask about. And then assignment restrictions. So an assignment is finding someone to take over the rest of the lease and then getting them to take on the liability, whereas a sublease is usually part of the lease or part of the time, and you still, as the leasee, has liability over that. So whether it's assignment or subleases, we have to ask if they're allowed. We also have to ask, um, does it trigger a landlord? I've read leases lately where a tenant suggesting to sublease or sign gave the landlord a right to terminate the lease just based on the suggestion. So that exists. And also saying in this that X, Y, and Z should not be deemed a sublease or assignment. So if I decide I'm a coffee shop and I want to have a plant store and I want to have a friend do a pop-up market, these should not be deemed me subleasing or signing. So I'm going to add to this clause that the landlord knows that these are not to be deemed as falling under the assignment restrictions. But that's another thing that you have to look at really closely. So the point is that small clauses or clauses that are vague or ambiguous can create major costs. They also lead to both sides being able to argue that you agreed to something that you didn't know you agreed to, or you didn't read because it was so boilerplate. We talked about this earlier, CAM charges. So a little bit more about CAM charges. They could include landscaping, security, parking lots, shared utilities. This is the property management one I mentioned. So in addition to asking about what these fees might be, we can ask about caps and allocation methods, but I also want it to be where you're allowed to ask for an audit. Sometimes it does give auditing as a clause, but it only puts the auditing on the landlord, or the landlord has the ability to use their own accountant for auditing. So it might be that you say that you not only have the ability to request an audit, but that the person who is auditing is a third party neutral or someone who you both agree to. Because if the landlord has a friend and the friend is the one who's doing the accounting or the bookkeeping, or they're only being given select information from the landlord and then they give a report and the report's not actually accurate. So we just want to make sure that not only do you have access to the breakdown of CAM charges, but if you had to do an audit or figure out the allocation, we see this a lot in buildings where there's multiple tenants. And so what happens is there are landlords who double dip where they charge higher. Basically, if you added all the percentages up, you get a higher than 100% for all the tenants who are there. So they're double. I don't know if double dipping is the word, but essentially, if there's two, I'm charging you both 60%. Well, if I'm charging you both 60%, that's higher than 100% of that thing. So that happens. Also, proportions are wrong. So, um, okay, yeah, we have a bigger place, but we're not running the water all day long. So why are we paying, you know, this percentage for water when we're not the ones who are using the water? So understanding how things are proportioned or being able to ask how they're proportioned or get audit information or allocation methods is extremely important. Like the allocation method part is like your landlord should be able to tell you how they got the number. So how did you get this number of what percentage I owe or what you're saying I owe? And if they don't have a good reason and they're just like making it up, then I mean we have a problem, right? So okay, so tenant improvements, a little bit more about that. So we want to ask if we're doing tenant improvements, not only who pays. So I talked about earlier that we can have one party pay or we can split them. But here's the thing, is a lot of commercial landlords, they like to use their own contractors. And who knows, are they getting a portion of that? Are they hiring their friends who maybe they're not getting a portion of that, but their friend doesn't do the highest quality work, but they're forcing you to use that contractor, and then you end up having that shoddy work. So who chooses the contractors? Who's gonna manage them? What if the landlord is managing the tenant improvement and it's your space, it's your business goal, and basically the landlord or owner tells this person, I believe that she wants the space to look like this. Well, they're not going to redo it for you after they've already done that. So you just need to make sure that the line of communication or the game of telephone for the contractors who are working on tenant improvements actually matches what your business plan and your goals and purpose are. Because I've been in a lot of situations where clients have allowed the land, and if they allow the landlord to manage it, that's fine if that's what they want and they've had the discussion. But if a landlord doesn't understand why you need something for your business or what it should look like or what its function should be, there could potentially be a disconnect there. Who gets permits? That's another tenant improvement issue of is the landlord pulling the permits? Are you? What does that mean? When does rent start? Talks about that. Does it start when our tenant improvement start? Does it start later? Does it start when I get the furniture in or when I have a first sale? Like we have to figure out the specifics of that. We don't want the landlord to come back and say, "Hey, you thought the rent was abated because it was for a couple months, but actually at this time it was no longer abated, so you now owe me for 3 additional months." Who owns the improvements later? This is kind of the fixture question that I was talking about. Um, Typically, if it's like adding walls and things, the landlord, of course, owns them. You're not going to take down a wall. But if you're adding industrial dishwashers and walk-ins and pizza ovens, really, it might be important in your lease or in a lease addendum to say that that thing is owed by this party or that party, or that if this party wants it, they have to pay a fee, etc. Okay, personal guarantees, we talked about that. And so you know what that is, but this is just breaking down types of personal guarantees. So we can have an unlimited personal guarantee where it's like anything, all things. It could be limited to certain liabilities or certain costs or capped. Um, this whole burn off or time based, it could be, like I said, after a year, you no longer have to pay and will not pay. You no longer are personally responsible if things go wrong because you've paid for a year and you're now trusted and your business has fulfilled this goal. And so we can get rid of the personal guarantee. So my biggest takeaway or my biggest note for this is if you do have a personal guarantee, most people do now, but try to make it so that after a certain time, that personal guarantee would drop off and or prior to them piercing the corporate veil to get your individual assets, you've agreed that X, Y, and Z have to happen so that you have a little bit of a buffer. This one's really big right now. And when I say big right now, it's like things that I've been talking about with clients. So after COVID, I mean, during COVID, we saw um, people were selling through service windows or patios on the street or all kinds of variations. And so at that time, I think landlords were a little bit more open to a variety of businesses and things like that, or ways to sell. I now take none of that for granted. So if a client is going to sell, like do pop-up markets or a resource fair in their driveway or parking lot, or um, you know, they're doing this or doing that. Like I have to make their permitted use can no longer say retail space or can no longer say office space. So if your lease says things that are as simple as that, then we have a problem because what's going to happen is the moment you do something else, it's going to be deemed violative of this permitted use clause. And so as a result, what we do is we try to make it broadly enough to cover current and future activities, whether that be goals. Like even though you're not having a pop-up market tomorrow, you're going to have a pop-up market during the holiday season. So we're going to add to this, including community events and pop-up markets and patio sales. And I mean, we can add any and all things, or we could add things broadly. But the main takeaway is that having it just say retail or office is not enough because the fear is that you don't want to do something and they believe that it's violative of your permitted use. I don't know why I have another slide for that. Oh, okay, because this is not CAM charges. This is related to maintenance and repairs. So one of the biggest issues I have with clients is the liability that they face related to things like HVAC or roofing. What happens is the default of boilerplate commercial leases, it places the liability for maintenance or replacement of the HVAC and roof and several other things on the tenant, and the tenant often doesn't know or doesn't take that seriously. So one is maybe you can negotiate that you split the cost. Another thing that I've the last several years told tenants is just like a when you're buying a home and you do a housing inspection, you can require that the landlord hire someone and give you a third party report. So like if the HVAC system looks really shady, we're going to agree to hire an HVAC expert to come and tell us like you have a year left on this, or it's about to bust, or this looks amazingly healthy. Because if you don't do that and you sign the lease and take on the liability for a variety of high cost items, you're sort of shit out of luck and you have to pay for those. And so I have had clients who didn't take that seriously and they came to me later and they ended up having to pay a good amount of money to either fix or replace the HVAC system or roofing or any of these other things. So asking if these things can be cost shared is good. Asking the state they're in, asking for an inspection to happen so that you get a third party report. Um, or you find out that you do know that this is going to break, but you actually get a quote now because if you're responsible for it, you think it's $5,000. If you don't get a quote now, you end up finding out in 6 months when it breaks that it's $15,000. So asking if you can get a quote for future work that may have to happen is a smart thing to do. Okay, so insurance and risk allocation. So, um, we all want general liability insurance. These are just a variety of insurance types. Sometimes they're one policy, sometimes they call them endorsements. They're one policy that kind of has additional policies or protections added to it. What we want to do is we want to layer our liability protection. So we need to know, does the landlord also have insurance? Like sometimes landlords have fire and flood insurance, but they don't protect the property that you have inside, just the building. Sometimes you have insurance that only protects your office, but doesn't protect storage or doesn't protect things you're selling. I mean, you have to sort of layer all the things. So we have to better understand what kind of insurance our landlord has and what kind of insurance we have or need, and how do they speak to each other. And then sometimes some of the insurance won't protect us, but it tells us that we need to give out a liability waiver to people who are on site doing certain things. It may say we need event insurance. So we're covered for all the things we're doing, but when we have an event, we're going to get specific event insurance because if we don't, if something happens during this event, it's not covered. I have a love-hate relationship with insurance. I really love it and tell clients to get it. I have a variety of types of insurance, including malpractice insurance. But the hard part is if you ask an insurance company what the thing will cover or not cover, they'll tell you that they can't tell you because it would be conclusive of a future claim that you don't yet have. So it's like, okay, yeah, I get that, but I need to know, what does this cover? The other issue is if you talk to an insurance salesperson or broker, they're often knowledgeable, but they're not the policy underwriter and they're also not the claims adjuster. So what they tell you, not that they have bad intentions, but it could be that they tell you something's covered, but then when it comes to an actual claim, it ends up not being covered. Two other tips are if you change the type of business or you change your programs or services or products, you should also look into see if the insurance covers that. A lot of clients, they get insurance from like 5, 10 years ago, and then they end up doing a different kind of business or different kind of project or program, and they don't see if their insurance would also cover that, or they don't make those changes. And so the problem is when something happens, the very thing that happens is the very thing that's not covered. So it's a false sense of security, and the claim is not fulfilled. Another thing is to ask insurance folks, if I were to pay, a little bit more, what would be the coverage increase? So I have some clients where when they filed a claim, they find out they got $5,000, but had they paid $50 more over the course of several years, they would have gotten $15,000 or $20,000. So knowing sort of, yes, this is the basic, what's your next best thing, and what's the difference? And is it worth me paying a couple bucks more to end up having a higher recovery? Those are all things to think about. Okay, growth, exit, assignment, and subleasing. So basically, I talked about this a little bit before. If you're renting a place, you really want to know, okay, well, what happens if I need to have a larger space or a smaller space, or I sell this, bring in a partner, sublease, relocate, all these things. So if your lease gives the landlord all kinds of abilities to come after you if any of these things happen, then we have a problem. Or if you sell a business and the person who's buying your business actually needs the space to do the business, the space that you're leasing, if your landlord's not going to automatically allow for that or let them have an assignment or sublease, or doesn't want to write a new contract with them, you're not going to be able to sell that business because some of the business may be the reputation or the location or the build out of that space. Um, so just finding out all these sort of things of what happens if this happens? What happens if I grow and don't need the space? What happens if I, need to have multiple people here? What happens if I sell it? So if you don't have information on what happens if any of these situations occur, then we have a problem because these are things that could end up uprooting your goals. So you bring in a new partner, and the landlord says, unfortunately, I have to end your lease because this lease is between you and not that partner. Or you change the type of business you do, and the permitted use is violated. Or you decide that you're going to sell the business, and upon sale, they can terminate your lease, but you actually need that lease to provide for the person buying the business. So you get it. There's a variety of circumstances that could happen when you're growing, exiting, assigning, subleasing. And if you don't know what the implications are for those, then we have a problem. So we need to figure that out. Okay, negotiation strategy. I was just looking at the time. I think we have plenty of time today. Um, yeah, 1 to 2:30, and it's 2. Okay, so we'll have a couple more slides, and then we'll do some questions. So negotiation strategy. So we want to prioritize personal guarantees. Again, what we decide to prioritize is up to us, meaning I have clients who they have to have this type of sign because they want the public to see their space in that way when they're driving down the freeway, right? Or they have to have, this type of landscaping, or they have to have this type of parking because if they don't, they're not going to have or a loading zone. You talk about daycare, like how are kids safely being dropped off in this highly trafficked area? So then if there is no possibility for a safe area in the parking lot to drop kids off. So what I'm saying is there's a variety of things that may relate to negotiation strategy that are not seen in this list. But primarily, we want to make sure that the personal guarantee, we either don't have one or we have one and we understand it, or it burns off, like I said, after a couple of years. Common area maintenance, we want to know how much are we paying for common area maintenance? Is there a cap? Repair obligations, are we sharing repair costs? Am I spending all the money on the repairs? Permitted use is one, because if I can't use this for the creative ways that I want, I can only use it as a retail space or an office space, then we have a problem. And then exit rights. It talks about that pretty recently. These are some red flags. Um, so unlimited guarantees, meaning like you have a personal guarantee forever. Now I'll tell you that this often occurs, and I've signed leases that have personal guarantees that are unlimited, and so have others. But I've made sure that the wording is a little bit different, making it so that there is check-in and communication. Another red flag, undefined CAM charges, automatic renewals. So I don't have a problem with automatic renewals, but if there's an automatic renewal, that upon renewal, there's a variety of increases in costs or charges that you don't know about or that you forgot about. Missing exhibits. So a lot of time these leases, it'll say like, see Exhibit D, and then Exhibit D is not there, or you know, see these rules, and those rules aren't. I've seen leases that are not labeled. The numbers aren't labeled correctly. There's missing clauses. There's a clause mentioned that you're agreeing to, but that clause is not there. So it's like, was that taken out? Am I agreeing to it, or is it in another spot labeled somewhere else? Vague rent escalations, and then verbal promises. So it doesn't matter if the landlord tells you, do this, do that. We have to put it in writing, and maybe it's not part of the main lease. Maybe it is you captured in an email and you say, does this mean that this thing you told me about will bind to the lease or integrate with the lease? Yeah, it does. Okay. So then if we had to pull up proof of that, we would have that proof. But this idea of verbal promises, a lot of people do that where it's like, well, you said on the walkthrough or that this we could do this. And none of those things really hold up because there's something in law called puffery where people who are doing sales, it's called like it's also called an invitation to offer or an invite to solicit, where um, there is a right to sort of get people excited and make these sort of promises. And the idea is they're not actually definite and certain, and they're not offers. And so if you accept something that wasn't meant to be a formal offer, but then you realize like that was a verbal promise that can't be upheld. So that happens a lot. So be careful with that. Or see the space and then email them out and be like, we really enjoyed seeing your space. It sounds like these things are true. Can you confirm that these are true? And then they'll say, yeah, those are true. But this one, no, we didn't really mean that. Okay, 10 questions before signing. Is it negotiable? What are the CAM charges? What does the fine print say? What contingencies do I need? Is my use legal? And when I say that, I don't mean like, selling crack cocaine. I mean, that's important too. I mean, is the zoning and permitting allowed for this space? So they say to me, "Oh yeah, you can run this as this kind of store. You can sell this. That's what my other clients sold." Like you don't know that for a fact. You have to figure that out. What am I guaranteeing? Who pays for improvements? What can I do in the space? Who handles repairs? And does this lease fit my business? So that is all. I will take questions. I know that's a lot to cover.
That was amazing, Michael. Thank you.
Yeah, very, very comprehensive. Can you go back to that last slide one more time? And then it was, this is least fit my businesses. Okay. I'm just taking notes here.
Yeah, no, you're good.
There's so many things to be aware of and to be cautious about. Like, wow. I mean, it's amazing.
And to
Well,
think of them all up front.
yeah, exactly. And no
Yeah.
wonder folks get into trouble with this in this area.
Oh, for sure. And then I also get it. I get like seeing a really great space, and you're just like, oh my God, this is a perfect space. And like maybe it is, but that sort of blinds us. I mean, it's maybe like Love is Blind too. It's like that idea of that perfect space that you found for your business can kind of blind you from all these other logistical things.
Mhm.
Yeah. Well, Well, thank you. And why don't we say goodbye to our future audience that's going to watch this after the fact, so that we can then ask Michael questions that are not on camera. So just going to say thank you, and if you have more questions, please send them our way. And thanks for watching.